The library at Harmon County Courthouse had not been opened in 11 years. Not because anyone had locked it. There was no lock on the door, just a brass handle worn smooth from decades of use, and a hinge that groaned like a man being woken from sleep. It sat at the end of the third-floor corridor, past the clerk's offices and the records room, and a vending machine that had been broken since the previous administration. Nobody went in there anymore. The county's legal reference materials had long since migrated to digital databases, and the room itself had become a kind of institutional forgotten drawer, the place where things went when nobody knew what else to do with them. Inside, stacked on oak shelves that had darkened with age, were old casebooks, property ledgers, land survey records from the 1800s, and 3 filing cabinets that nobody had the keys to anymore. There was also, laid flat on a velvet-lined display case that had been dragged in sometime in the 1970s, a document. The document was the reason everything that was about to happen would happen. It was 43 pages, hand-lettered in brown ink on heavy parchment that had aged to the color of weak coffee. The first page bore a wax seal, a crest of some kind, partially cracked, and a date. September 14th, 1887. It had been discovered 3 weeks earlier during a renovation of the courthouse basement, tucked inside a cedar box, wrapped in oilcloth that had held its integrity with remarkable stubbornness for nearly 140 years. A county contractor had found it behind a false wall. The contractor had handed it to a clerk. The clerk had handed it to her supervisor. The supervisor had handed it to the county attorney's office. And then the calls had started. Because what was written in that document, what could be made out of it, at least, appeared to describe a land arrangement involving more than 800 acres of what was now the most commercially developed stretch of Harmon County, Georgia. An arrangement that, depending on how it was interpreted, might affect the deed status of property's worth, collectively, somewhere north of $200 million. The problem was that nobody could read it, not fully, not with confidence. The document was written in a dialect of English that had long since passed out of use, a formal, highly compressed legal register that blended elements of 19th-century contract law with what at least 2 consultants had tentatively identified as Gullah Creole notation, a system used in certain low-country legal documents of that era by attorneys who had been trained in a tradition that crossed African linguistic structures with English common law forms. It was, as one professor of legal history at Caldwell University had put it in an email that was now being read aloud in a conference room full of very anxious lawyers, genuinely unusual, possibly unique. I'd need at least 6 months to produce a reliable translation, and even then I'd want peer review. 6 months was not what anyone had, because in 17 days, though the Harmon County Superior Court was scheduled to hold a hearing on the Whitmore land claim, a suit filed by a coalition of black landowners in the eastern part of the county, who were arguing that a series of property transfers dating back to 1962 had been fraudulent, and that the original ownership of those 800-plus acres had never been legally conveyed away from their ancestors. The coalition had been fighting this case for 6 years. They had a new attorney. They had community support. And they now had the document, which their attorney believed was the deed of original conveyance, the one that had been missing from the record for over a century, the one that, if properly translated, might prove everything. The county's legal team, representing the corporate developers who currently held title to 3 of those parcels, had already begun their counter-strategy. Argue that the document was unreadable, undatable with precision, and legally indeterminate. If they could establish that no reliable translation was possible, the document would be inadmissible. And without the document, the Whitmore Coalition had a compelling story and a very difficult evidentiary problem. 17 days. Nobody at the courthouse that Tuesday morning, Not the bailiffs, not the clerks, not the 2 county commissioners who had come down personally to look at the thing through the display case glass, was thinking about Marcus Tillman. Marcus Tillman was 14 years old. Before we go any further, where are you watching from right now? Drop your city in the comments. I read everyone, and I'm always curious to see how far these stories reach. But he lived 6 blocks from the courthouse on Decatur Street, in a duplex that his grandmother, Evelyn Tillman, had rented for 22 years. The duplex was not large. 3 bedrooms, 1 bathroom, a kitchen with a window that faced the neighbor's chain-link fence, and a living room that smelled perpetually of the cedar oil Miss Evelyn used on the furniture every Sunday morning without fail. The carpet was old but clean. The walls held photographs. Marcus's mother in her high school graduation gown, a picture of his grandfather in his army dress uniform, a framed print of Harriet Tubman that had been there since before Marcus could remember. His mother, Denise, worked as a medical billing specialist at a clinic across town. She left the house at 6:40 every morning and came home at 5:15, 6 days a week. On the 7th day, she did laundry and grocery shopping and went to church. She was 34 years old and tired in a way that had nothing to do with sleep. She was also in the way of people who are tired and 34 and carrying a great deal, fiercely, specifically, pointedly proud of her son. Marcus's father had not been in the picture since Marcus was 3. This was a fact that Marcus had long since metabolized into something that did not require regular examination. He had his grandmother, he had his mother, he had the library. The public library was 8 blocks from the duplex, and Marcus Tillman had been going there since he was 6 years old, initially accompanied by Miss Evelyn, and then, from the age of 9 onward, alone. The librarian, a soft-spoken woman named Mrs. Hatcher, had, over the course of those 8 years, developed a comprehensive mental model of Marcus Tillman's reading habits and had reorganized an entire section of the reference shelves, partly on his behalf. He read everything. That word is used loosely, all the time, applied to people who read a lot, who read widely, who read across genres. In Marcus Tillman's case, it was meant with precision. He read history, he read science, he read legal texts, not textbooks, actual casebooks and statutory compilations, because Miss Evelyn had found a box of them at an estate sale when he was 10, and he had devoured them the way other children devoured comic books. He read linguistics. He had taught himself, using library materials and a donated laptop, and a YouTube playlist that he had assembled himself, to read Latin, and then, because Latin had led him to early Romance languages, intermediate French, and then, because French had led him to the Caribbean, to a working reading knowledge of Haitian Creole, which had led him, at age 11, to a book called Voices from the Low Country, Linguistic Structures of the Gula Communities, 1800 to 1950. He had read it 4 times. He had not read it because anyone told him to. He had not read it because it had any immediate practical application. He had read it because it was there, and because the language described in it, the way it worked, the way it braided African grammatical structures onto English vocabulary, the way it preserved in its syntax a kind of historical record of people who had not been permitted to leave written records in other forms, had struck him, at 11 years old, as one of the most remarkable things he had ever encountered. He had, subsequently, read everything the library had on the subject. He had, at 12, found an academic linguistics journal online that published papers on Gula language documentation. He had, at 13, written a letter to one of the researchers, a professor at a university in South Carolina, asking 3 specific questions about tonal variation in late 19th century Gullah Creole legal notation. The professor had written back. And then they had corresponded, 11 emails over 14 months, because the professor had quickly recognized that the questions Marcus was asking were not the questions of a curious child, but of a serious student. None of this was known at the Harmon County Courthouse. Marcus Tillman was known at the courthouse in a different context entirely. 2 years earlier, at 12, that he had been brought in with 3 other boys from his middle school, walked through the side entrance, past the metal detectors, into a room with fluorescent lights and plastic chairs, because they had been in the wrong place at the wrong time when a fight broke out at a bus stop. Nothing had been charged. Nothing had happened to him, legally. But he remembered the way the clerk at the front desk had looked at the 4 of them. He remembered the way the security guard had not looked at them at all, had looked above them, through them, as though they were a weather system rather than 4 12-year-old boys. He had not been back since. Miss Evelyn had family on the eastern side of the county. Her sister's people had owned land out there, had owned it before Marcus's grandfather was born. She talked about it sometimes, at the dinner table, in the particular register that old people use when they are describing something that was taken from them before they had the language to fight for it. Marcus had listened. He had always listened carefully. And when the Whitmore land case had started appearing in the local news 2 years ago, first a small item in the Harmon County Gazette, then a longer piece, then a community forum at the Baptist Church on 5th, he had started paying attention in a different way. He had gone to the public forum. He had sat in the back row. He had listened to the attorney, a woman named Renata Cole, who had driven down from Atlanta to take the case on a reduced fee, lay out the basic argument. He had listened to the developer's representative, or some man in a blue suit who had stood at the front of the church fellowship hall and spoken about legal certainty and market stability and the impracticality of disturbing settled title with insufficient documentation. The man had said insufficient documentation 4 times in 20 minutes. Marcus had gone home and read every land title case he could find that involved disputed historical documents. That was his world. That was who he was. A 14-year-old boy with a library card, a correspondence with a linguistics professor, a grandmother whose people had once owned land that was now a strip mall and 2 condominium developments, and absolutely no standing, no credentials, no access to the room where the document sat in its velvet-lined case on the 3rd floor of the Harmon County Courthouse. Now that you know who Marcus is, I have to ask you something. Have you ever known someone like him? Someone carrying more knowledge than the world gave them credit for, whose worth just hadn't been seen yet? Tell me about that person in the comments. The call that changed everything came on a Wednesday afternoon, and it came not to Marcus, but to Miss Evelyn. It came through the network that Black communities in small southern cities have maintained for generations. Not a formal network, not an organization with letterhead, just the knowledge of who knows whom and who to call when something needs to happen. Miss Evelyn's sister had called her. Miss Evelyn's sister had heard from a woman at the Baptist Church, who had heard from someone in Renata Cole's support group, that the attorney was desperate. The translation consultant from Caldwell University had officially declined, citing the timeline. A second specialist, a retired professor from a university in Virginia, had reviewed photographs of the document and said he could offer nothing definitive within 17 days. A third expert, a linguist from a university in Louisiana who specialized in Creole language systems, had asked for $10,000 up front and a minimum of 3 months. The Whitmore Coalition had $6,000 in their litigation fund. Total. Miss Evelyn had sat with that information for about 20 minutes. Then she had walked to the kitchen doorway and looked at Marcus, who was at the kitchen table with a library book, a yellow legal pad covered in notes, and the bowl of cereal he had been theoretically eating for the past 40 minutes. "So, Marcus," she said, "come tell me what you know about that courthouse document." He looked up. He had, of course, already heard about the document. It had been in the Gazette. He had read the article 3 times. He had, in fact, been thinking about it with a specific and focused intensity for the past week. But he had not said anything because he was 14 years old, and the idea of walking into a courthouse and telling adults that he could do what trained professors could not had seemed to him, practically speaking, insane. "I think I can read it," he said. Miss Evelyn looked at him for a long moment. "You think, or you know?" "I'd need to see the actual document, not photographs, but based on what was described, the construction, the notation style, yes, ma'am, I believe I can read it." Miss Evelyn sat down across from him. "Then tell me everything you know about why you can read it and nobody else can." He told her. It took 40 minutes. He explained about the Gullah Creole legal notation system. He explained about the late 19th century practice among a small number of low-country attorneys, almost all of them black men who had been trained in informal legal traditions before and during Reconstruction, of using this hybrid notation system for land documents involving black families, partly as a security measure and partly as a preservation of a linguistic tradition. He explained about the specific phonological features that distinguished this notation from standard written Gullah. He explained about the researcher in South Carolina and showed Miss Evelyn 2 of their email exchanges on the laptop. Miss Evelyn read the emails twice. She was not a woman given to dramatic expressions of emotion, but she reached across the table and put her hand over his. "Okay," she said, "I'm going to make a call." Renata Cole was, in her own estimation, not a woman who was easily surprised. She had been practicing civil rights law for 11 years. She had represented clients in federal court at 31 years old. She had, earlier in this very case, argued a preliminary motion before a judge who had visibly and repeatedly looked at his watch while she was speaking. She had stood in rooms where she was the only black woman and the only person who believed what she was saying was true, and she had kept saying it. But when Miss Evelyn Tillman called her Thursday evening and explained the situation, Renata Cole sat down slowly on the edge of her hotel bed and said, "How old did you say he is?" 14, Miss Evelyn said, "but I need you to talk to him before you decide what that means." Renata drove to Decatur Street Friday morning. She sat at the same kitchen table where Marcus had eaten his cereal, and she asked him everything she could think to ask. She tested him. She had brought printed photographs of the document, the same photographs she'd sent to the consultants, and she watched him work through them. He translated the first page in 11 minutes, reading aloud, slowly, explaining as he went. The legal language was dense. It would need to be formalized, cross-referenced against 1887 Georgia property law statutes. But the meaning was clear, and the translation was, as Renata checked it against the fragments she'd already had verified, accurate. She watched him, as he was 14 years old, sitting at his grandmother's kitchen table in a gray hoodie, translating a document that 3 credentialed academics had declined to touch. He wasn't performing. He wasn't nervous. He was reading. "Marcus," she said when he paused, "where did you learn this?" "The library," he said, in a tone that suggested this was the only honest answer. She looked at Miss Evelyn. Miss Evelyn's expression said, "I told you." Here was the problem, and Renata Cole identified it immediately because problem identification was her profession. Marcus Tillman was a 14-year-old child with no credentials, no published work, and no standing as an expert witness. The opposing counsel, a senior partner from a firm in Atlanta named David Hartwell, who had been representing developer interests in Harmon County for 15 years, would destroy a 14-year-old witness. The judge, an older man named Clarence Mabry, who had been on the Harmon County Superior Court bench for 20 years, was unlikely to accept a minor as a forensic linguistics expert without extraordinary justification. There was also the matter of Marcus's prior contact with the courthouse system, the bus stop incident 2 years ago. It was nothing. It had gone nowhere. But Hartwell would find it because Hartwell found everything, and he would use it the way people like him always used such things, not as evidence of anything, but as atmosphere, as suggestion, as a way of making a judge's brain ask the wrong question. Renata Cole had 14 days. She made 3 calls that afternoon. For the first was to the linguistics professor in South Carolina, Marcus's correspondent, whose name was Dr. Pauline Osei. Dr. Osei had been trying to reach the document through the university channels and had been met with institutional delays. When Renata told her about Marcus, there was a silence on the phone, and then Dr. Osei said, quietly and with conviction, "I know exactly who he is. We've been corresponding for over a year. Put him on the phone." The second call was to a retired federal judge named Harold Gaines, who had served on the 11th Circuit and who was now, in his late 70s, something of a legend in Georgia civil rights legal circles. She asked him a specific question about the admissibility of expert testimony from individuals without formal academic credentials under Georgia evidentiary rules. But he gave her a 40-minute answer that ended with, "It's been done. It's rare. You'd need to establish expertise through demonstrated knowledge, not through title. The knowledge has to be real, and it has to be verifiable, is it?" "Yes," she said. "Then build your foundation," he said. "Don't apologize for him. Don't make him small to get him in the door. Present him exactly as he is and make the court understand why what he knows matters more than what his resume says." The third call was to Marcus's mother, Denise, who had not yet been told the full scope of what was being proposed. That call lasted 2 hours. At the end of it, Denise Tillman sat in her car in the clinic parking lot for a long moment, and then she called her son and she said, "Baby, tell me this is something you want to do. Not for me, not for Mama. And tell me this is something you want." And Marcus, sitting at the kitchen table with his yellow legal pad, said, "I've been reading about this case for 2 years, Mom. I know the document, I know the language, I know why it matters." He paused. "These were real people's land. Someone needs to say what that document says. I can say it." Denise Tillman closed her eyes. "Okay," she said. "Okay. Then we do it right." The 9 days that followed were unlike anything Marcus Tillman had experienced, which was saying something, given that he had already lived an unusually interior and studious 14 years. Dr. Pauline Osei flew to Harmon County from South Carolina on the Sunday after Renata's call. She was 51 years old, with close-cropped, silver-laced hair and the focused, evaluative manner of someone who had spent 30 years in academia, not tolerating imprecision. She sat with Marcus for 3 days. She tested him systematically, the way you test the load-bearing capacity of a structure before you put weight on it. She asked him about phonological drift in Gula documentation between 1870 and 1900. She asked him about the specific legal shorthand conventions used in low-country black attorney practice. She asked him about a notation system that she had published 2 papers on that she had never publicly described in plain language, and she watched his face as he explained it back to her, using his own terms he had arrived at independently. On the 3rd day, she looked at Renata Cole and said, "He's not just literate in this, he's advanced. More advanced than most of my graduate students." She paused. "What he has is not credentialed, but it is real. The foundation motion needs to be airtight." Renata was already working on it. She filed her motion to qualify Marcus Tillman as an expert fact witness on day 7. It was 42 pages. It included his correspondence with Dr. Osei, an affidavit from Dr. Osei attesting to the depth and accuracy of Marcus's knowledge, a 5-page summary of the library-based independent study Marcus had conducted over 3 years, and a 14-minute video recording of Marcus translating a section of the document, a controlled, documented exercise conducted with Dr. Osei present and notarized. David Hartwell filed his opposition the next morning. It was 29 pages. It argued, methodically, and with the smooth confidence of a man who had been arguing in courts for 20 years, that Marcus Tillman was a child. That child testimony in expert capacity had never been accepted in a Georgia property dispute of this magnitude. That the methodology of his preparation was insufficiently documented, and that, buried in paragraph 17, mentioned as if in passing, the witness had a prior contact with the Harmon County court system that raised questions about his credibility as a court participant. Renata read that paragraph 4 times. Then she set it aside and finished preparing her direct examination outline. The hearing was on a Thursday. The courtroom was not large. It had 12 rows of public gallery seating, dark wood paneling, a Georgia state seal on the wall above the judge's bench, and windows that let in the pale morning light of late October in a way that made everything look slightly overexposed. By 8:45, every seat was taken. Word had gotten out, through the same networks that had gotten word to Miss Evelyn, through the Baptist Church and the neighborhood associations and the community Facebook group and the Harmon County Gazette, which had run a front-page story the day before under the headline, "Teen Called as Key Witness in Landmark Land Case." Miss Evelyn was in the second row. Denise Tillman was in the first row, directly behind the plaintiff's table, her hands folded on her lap with a stillness that cost her something. Dr. Osei sat in the gallery 3 rows back, her briefcase on her lap, watching. Marcus Tillman sat at the plaintiff's table in a charcoal gray suit that Denise had driven 45 minutes to buy from a department store in Atlanta. The suit fit him well. His hair was freshly cut. He had a legal pad in front of him, a pen he had not yet uncapped, and an expression of calm that was either genuine or was what genuine looked like when you had prepared as thoroughly as he had. After what you just heard David Hartwell do in that courtroom filing, using a bus stop incident from 2 years ago to try to undercut a 14-year-old kid who just wants to speak the truth, what would you have done in Marcus's position? Let me know in the comments. Judge Clarence Mabry was 67 years old, with the unhurried manner of a man who had sat on this bench for 2 decades and had heard a great many things and been surprised by very few of them. He read the foundation motion. He read the opposition. He asked Renata 3 questions, and Hartwell 2. Then he looked at Marcus. "Young man," he said, "you understand what's being proposed here. You'd be testifying as an expert in a matter that professional linguists with PhDs have declined to take on in the available time. Before I rule on admissibility, I want to hear from you directly. Not your attorney. You." Renata nodded slightly. This had been discussed. Marcus stood. "Yes, sir." "Tell me, in your own words, how you know what you know about this document. What Marcus Tillman did in the next 7 minutes was not a performance. It was not a speech. It was explanation. The same explanation he had given Miss Evelyn at the kitchen table, except more organized, more precise, and delivered to a man who had the authority to decide whether it mattered. He described the linguistic system. He described his independent study. He described his correspondence with Dr. Osei. He described, with specific reference to the document, the features that made it readable to him and difficult for generalist linguists. The compressed legal notation, the tonal markers, the specific vocabulary conventions used by low-country black attorneys in the late Reconstruction period. He stood straight. He made eye contact. He spoke at the pace of someone who was thinking carefully, not rushing, not performing confidence, but actually feeling it. The deep, specific confidence of someone who knows something real. When he finished, Judge Mabry looked at him for a long moment. Then he looked at Hartwell. "Counselor, I've reviewed Dr. Osei's affidavit and the video demonstration. I am prepared to qualify Mr. Tillman as an expert fact witness on the specific subject of Gullah Creole legal notation in late 19th century Low Country documents. Your objection is overruled. We'll proceed." Hartwell's face did not move, but his jaw tightened, fractionally, in a way that his junior associate noticed and looked away from. We are right at the edge of the moment everything changes for Marcus. Before I tell you what happened next, what do you think happened when he took that witness stand? Drop your prediction in the comments. I want to see how many of you called it. Renata walked Marcus through the document section by section. She had a projected copy on the courtroom screen, large, clear, each page photographed in high resolution. Marcus translated it in real time, with Dr. Osi in the gallery following along on her own copy, her expression unchanging, her silence itself a form of attestation. The document was, as the coalition had believed, a deed of original conveyance. It was dated September 14th, 1887. It transferred 4 parcels of land in eastern Harmon County, totaling 812 acres, to a man named James Whitmore and his descendants, in perpetuity, in exchange for services rendered and in settlement of a debt, the nature of which was described in the Gula legal notation in terms that Marcus translated as labor given without compensation to be made whole in land. In other words, the land had been given as restitution, as acknowledgement, as a form of legal repair. Marcus translated every page. He explained every notation. When he reached the passages that had defeated the other consultants, 3 pages in the middle of the document where the notation became densest, where the Low Country legal shorthand was most compressed, he paused, looked at the projection, and worked through it with the methodical clarity of someone who had spent 3 years earning the right to understand it. There were people in that gallery who were crying before he finished. Hartwell's cross-examination lasted 40 minutes. He was good. He was very good. He challenged Marcus's methodology, his age, his lack of formal academic training, the absence of peer-reviewed publication, and the impossibility of independently verifying the translation without a second expert, he noted, who had not materialized. He was calm and precise and professional, and he made every argument available to him, and he made them well. Marcus answered every question, not combatively, not with a 14-year-old's defensiveness, with the same measured specificity he'd brought to the direct examination. When Hartwell pressed him on a particular notational choice in the document, arguing that an alternate reading was possible, Marcus acknowledged the alternate reading, explained precisely why the syntactic context ruled it out, and cited, from memory, a parallel construction in an 1891 document from Beaufort County that Dr. Osi had published in her 2018 paper. Hartwell paused. "You've read Dr. Osi's 2018 paper?" "All 3 of her papers on Low Country legal notation," Marcus said, "and the 2 that were published in response?" There was a sound in the gallery, not quite a laugh, something quieter and more complicated. Hartwell had no further questions. Judge Mabry did not rule from the bench that day. He took the matter under advisement, as expected. The full ruling would come 3 weeks later. But what happened outside the courtroom, in the hours and days that followed the hearing, was its own kind of verdict. A video clip from the courtroom, audio only, the translation portion, about 4 minutes, was recorded by a journalist from the Gazette and shared to a local Facebook group. By midnight, it had 40,000 views. By the following morning, it had been shared to 3 national social media platforms and was trending under the story of the Whitmore land case. By the following afternoon, the clip had been picked up by 2 national news outlets and a legal affairs podcast with 200,000 subscribers. The story was not Boy Genius Shocks Courtroom. That framing was offered, and Marcus's mother rejected it in the one interview she agreed to with the Gazette. The story, as Denise Tillman framed it, quietly and precisely, was this: a child who was given access to a library and the freedom to follow his curiosity had developed knowledge that the system needed and didn't have. And the system, this once, had been willing to listen. 3 days after the hearing, Dr. Osei received a call from the chair of the linguistics department at her university, was asking about the possibility of a joint research project documenting Gullah legal notation systems, a project that Dr. Osei noted to Renata Cole when she relayed the call had been proposed and underfunded for 11 years. The hearing, the attention, the 14-year-old at the witness stand. It had moved something that had been stuck. Marcus's crown was seen, finally, fully, by a room full of people who had no choice but to look. And I want to ask you something personal. Have you ever had a moment where someone finally saw your worth? Where the thing you'd been carrying quietly was suddenly recognized? Share that story in the comments. Someone watching this right now needs to hear it. Judge Mabry's ruling came on a Tuesday morning in November, 23 days after the hearing. It was 31 pages. Though the first 14 pages addressed the admissibility question, he affirmed his oral ruling qualifying Marcus as an expert fact witness, and he spent 6 of those pages responding systematically to every argument Hartwell had raised in post-hearing filings. The language was measured and judicious, as judicial language is, but the conclusion was unambiguous. The witness's demonstrated knowledge was real, documented, and had withstood cross-examination. The credential argument, the judge wrote, would exalt form over substance in a manner that this court declines to do. The remaining 17 pages addressed the document itself. Based on Marcus's translation, corroborated by Dr. Osei's expert review conducted in the 3 weeks following the hearing, the court found the document to be an authentic deed of conveyance of the specified parcels. The property transfers of 1962 that the Whitmore Coalition had challenged were, on the basis of the historical record now established, legally defective. The matter was referred for further proceedings on the question of remedy. What exactly the 800 acres meant now, who owed what to whom, what could be returned and what could be compensated, which would involve years of additional litigation and negotiation. Nobody told Marcus Tillman it was simple. Nobody told him it was over. Renata Cole, sitting with him and Miss Evelyn and Denise at the kitchen table 2 days after the ruling, was explicit. This was a beginning, not an ending. There were appeals coming, or there were remedy proceedings that would be complicated and contentious and long. The developers who held those parcels had resources and counsel and the advantage of possession. The road ahead was not straight, but the document had been read. The record had been established. The court had said, in 31 careful pages, that the language of the dispossessed mattered, that it was legible, that it deserved a witness. And the witness had been a 14-year-old boy from Decatur Street who had spent years in a library because the library was open and the books were there, and nobody had ever told him there was anything in them he wasn't supposed to understand. The Harmon County School District, and in a response to the media attention that was partly goodwill and partly institution protecting itself from the implicit critique of the story. That a child had educated himself because the school system hadn't offered him the resources he'd been reaching for, announced a new initiative in January. A linguistic and legal studies elective track at the middle and high school levels, partially funded by a grant that Dr. Osei's university helped the district apply for. The grant was $47,000. It wasn't transformative, but it was a beginning. Dr. Osei's research project on Gullah legal notation received full university funding in February. Marcus was named as a junior research contributor, a title that had to be invented, here because the university's research credit system did not have a category for 14-year-old boys from Decatur Street. Dr. Osei invented it anyway. Renata Cole continued the Whitmore remedy proceedings. She did not expect it to be fast. She expected it to be true. Those were not the same thing, and she had long since made her peace with that difference. Marcus Tillman went back to school on the Monday after the ruling. He walked into his 7th period history class 4 minutes late because he had stopped at his locker for longer than usual and his history teacher, a man named Mr. on Draper, who had been teaching at Harmon County High for 9 years, and who had watched the courtroom audio clip on his phone in the school parking lot 3 weeks ago, and had not entirely known what to do with what he felt. Looked up when Marcus came in, and, without saying anything about it directly, nodded at him with the specific gravity of someone acknowledging something real. Marcus took his seat. He took out his notebook. Mr. Draper resumed the lesson, which was about reconstruction. Miss Evelyn's sister's family was in contact with Renata's office about the remedy proceedings. There were forms to file and affidavits to provide, and a long process ahead. Miss Evelyn herself had become, in the months following the hearing, something of a connector, the person people called when they needed to know who to call. And the network that had always existed in her community had not grown larger so much as it had become more visible, more legible to itself, more sure of what it knew. Every Sunday morning, she still put cedar oil on the furniture. The house still smelled of it. The photographs on the wall had not changed. Marcus's mother in her graduation gown, his grandfather in his army dress uniform, Harriet Tubman in her frame. There was one new addition. Denise had framed a printout of the first page of the ruling. Just the first page, the part that said the witness's knowledge was real, and the court had declined to exalt form over substance, and put it on the wall in the hallway, next to the photograph of her son taken at the courthouse on the day of the hearing. He was standing on the courthouse steps in the charcoal suit, looking at the camera, and not smiling exactly, but with an expression that was something close to it, an expression that knew something. That expression had always been there, for anyone who had known how to look. It was the same expression he'd had at 6, reading at Miss Evelyn's knee. At 10, working through the case books from the estate sale box. At 14, sitting in a library with a yellow legal pad and a bowl of cereal going soggy while the world went about its business of not yet knowing what he knew. The world had caught up for a moment. It had been required to listen, and the listening had mattered. Not because one hearing and one ruling would fix everything that needed fixing, but because the record now said what the record needed to say, in a language that had survived 140 years of being unread. For the document was returned to the county archives after the proceedings. It was assigned an accession number and placed in a temperature-controlled storage drawer with an acid-free folder. It would be there, cataloged and accessible for anyone who needed to find it. The library on the 3rd floor of the courthouse was still mostly unused, but sometime in December, a clerk noticed that the door had been oiled. The hinge no longer groaned. Someone had taken care of it. Nobody knew who had done it. Nobody asked. It was the kind of thing that, in certain communities, in certain places, gets done quietly and without announcement, because the doing is the whole point, because sometimes the record just needs to be made legible, and sometimes the person who can read it has been there all along. So if you believe that Marcus Tillman's story deserved to be heard, that knowledge shouldn't require a credential to matter, that the language of the overlooked deserves a witness, share this with someone tonight. Hit subscribe, because there are more crowns being claimed on this channel, and I don't want you to miss a single one.